Madam Speaker, I beg to move that a bill entitled An Act to Amend the Interpretation Act, Chapter 3, Number 1, the Supreme Court of Judicature Act, Chapter 4, Number 1, the Offences Against the Person Act, Chapter 1108, the Criminal Procedure Act, Chapter 12, Number 2, and for other related matters be now read a second time. Madam Speaker, we are here today, assembled in this august House, to pass the Miscellaneous Provisions Criminal Proceedings Bill 2021. The bill in question amends 4 substantive pieces of legislation. 1, the Interpretation Act, Chapter 3, Number 1. 2, the Supreme Court of Judicature Act, Chapter 4, Number 1. 3, the Criminal Procedure Act, Chapter 12, Number 2. And 4, the Offences Against the Persons Act, Chapter 11, Number 8. The bill, Madam Speaker, seeks to amend the Interpretation Act, the Supreme Court of Judicature Act, and the Criminal Procedure Act in relation to the relaxation of the rule against double jeopardy. The bill seeks to amend the Offences Against the Persons Act in relation to the abolition of the year and a day rule. I will elaborate on those rules momentarily, but first let me briefly indicate how those amendments arose. Madam Speaker, in 2021, the Law Reform Commission, in the Office of the Attorney General and Ministry of Legal Affairs, prepared 2 policy papers entitled 1, a review of the double jeopardy rule, and 2, a review of the year and a day rule. The Commission did extensive research on the jurisprudence behind these 2 rules. The Office of the Attorney General and Ministry of Legal Affairs thereafter conducted stakeholders' consultations regarding these policies. The following stakeholders were consulted: the Judiciary, the Office of the Director of Public Prosecutions, the Trinidad and Tobago Police Service, the Public Defender's Department, and the Law Association of Trinidad and Tobago. I should point out that both the Judiciary and the Trinidad and Tobago Police Service were in full support of these amendments. I will now address the rule against double jeopardy, Madam Speaker. That rule has been a part of the common law since its introduction to English law in the 12th century. The rule is based on the principle that a person should not be punished for the same offense on more than one occasion, and is represented by the Autrefois Doctrine and the DPP Connelly Principle. Madam Speaker, the rule of Autrefois Acquis and Autrefois Convie provide that a person should not be tried a second time for an offense of which he has been acquitted or convicted by a court of competent jurisdiction. The Connelly Principle arose out of the case of Connelly against the DPP, reported at 1964 Peel Cases 1254. In that case, the House of Lords stated that the principle of Autrefois is grounded on the maxim that a man shall not be brought into danger of his life for one and the same offense more than once. And the House of Lords held that a person could not be tried for the same or substantially the same offense unless the prosecution was able to prove the existence of special circumstances warranting a second prosecution, as confirmed by the Queen and Beattie 1998 Queen's Bench 356, which stated that for the doctrine to apply, it must be for the same offense in both fact and law, and no man should be punished twice for an offense arising out of the same or substantially the same set of facts. The rule against double jeopardy persists today mainly because it continues to provide a degree of finality and conclusiveness to defendants, victims, witnesses, and persons involved in criminal proceedings. Over time, however, Madam Speaker, strict application of the rule has led to situations where guilty persons have been able to escape the arm of justice. The rule is grounded not in the common law so much as it is a rule of, not so much in the Constitution, so much as it is a rule of common law. It is not an enshrined right as a fundamental right in sections 4 and 5 of the Constitution, but have been recognized at common law and at statute for centuries. The rule will not, therefore, automatically gain constitutional protection simply because it existed prior to the enactment of the Constitution. And we have had recent case law that has spoken to that, both from the Court of Appeal of Trinidad and Tobago and the Judicial Committee of the Privy Council in other factual circumstances. The rule, therefore, does not form part of the entrenched fundamental human rights set out in sections 4 and 5 of the Constitution, namely the right to a fair trial, due process, or protection of the law, and therefore an abolition or variation of the rule will not infringe upon any of those entrenched rights, and thus a special majority of this House will not be required. Madam Speaker, a strict application of the rule has led to situations where guilty persons are allowed to escape the arm of justice. Advances in forensic science and DNA testing have a fundamental impact on the rule, as it is now possible to produce new and compelling evidence pointing toward guilt long after an offense was committed. It must be noted, Madam Speaker, that other common law jurisdictions, including notably the United Kingdom, Australia, New South Wales, Queensland, South Australia, and Victoria, and New Zealand, have relaxed the rule to allow a retrial of an acquitted person in 2 exceptional circumstances. That is to say, where there is new and compelling evidence or where there was a tainted acquittal. In those circumstances, Madam Speaker, we look at the Interpretation Act. The rule against double jeopardy has been well established in English common law. The rule is not enshrined but is codified under Section 62 of the Interpretation Act, which provides that where an act constitutes an offense under 2 or more laws, the offender is liable to be prosecuted and punished under either or any of those laws, but a conviction or an acquittal upon a prosecution is a bar to prosecution for the same offense or for an offense which is substantially the same offense under any other of those laws, unquote. Clause 3 of the bill in the circumstances, Madam Speaker, seeks to amend the Interpretation Act by inserting a Section 61(1) AA, that is to say double A, which will provide that acquittals for offences specified in the proposed Schedule 1 of the Supreme Court of Judicature Act would not be a bar to prosecution for the same offence where there is new and compelling evidence or a tainted acquittal, and it is in the interest of justice that there be a retrial. I emphasize the fact that, therefore, there must be new and compelling evidence or a tainted acquittal, and it must be in the interest of justice that there be a retrial. The reason for this amendment is to create, therefore, 2 distinct and separate exceptions to the double jeopardy rule in instances where the accused was acquitted of a serious crime of which there is new and compelling evidence or the acquittal was tainted. The tainted acquittal procedure is different from a new evidence exception to the double jeopardy rule because the first proceedings were in truth a nullity. New and compelling evidence is to remove the hardship of not being able to prosecute again when new and compelling evidence arises. In modern conditions, an absolute protection would sometimes lead to an injustice. In the case of a tainted acquittal, this is influenced by the tainted acquittal procedure introduced by the United Kingdom Criminal Procedure and Investigations Act, 1996. The procedure is available where a person has been convicted of an administration of justice offense involving a juror and witness interference or intimidation. This second category, Madam Speaker, is to allow a retrial of an acquitted person as necessary because no one should be able to profit from criminal acts intended to undermine the criminal justice system by striking at its very roots, that is to say, evidence. A relaxation of the rule will therefore remove the strict application of the rule, which has led to situations where guilty persons have been able to escape the arm of justice. In the case of the Supreme Court of Judicature Act, Madam Speaker, Clause 4 of the bill provides for the necessary procedural requirements to facilitate the relaxation of the rule against double jeopardy. The Supreme Court of Judicature Act has been amended to insert after 65, Section 65Q, a new Part 11, Part 2C, entitled Applications to Quash Acquittals by the the Director of Public Prosecutions. It should be noted that the application of this part would only apply to offences committed after the commencement of this part. It is not intended to apply retroactively. The purpose of this amendment, Madam Speaker, is to set out the procedure to permit the Director of Public Prosecutions to make an application to the Court of Appeal to quash the acquittal and order a retrial of a person acquitted of specific serious offences. In that respect, Madam Speaker, there are a number of detailed reasons for the amendments. The bill provides the following: an application for retrial of an acquitted person should not be made if the acquitted person was acquitted of the offence charged but was convicted of a lesser offence arising out of the same set of circumstances that gave rise to the acquittal, unless the acquittal was a tainted acquittal. Where the Commissioner of Police sees the need to carry out an investigation of an offence listed in Schedule 1 of the Act, he must apply to the Director of Public Prosecutions before commencing the investigation. The DPP shall then advise whether the acquittal is a bar to prosecution, and if not, shall give written consent for the Commissioner of Police to commence the investigation. The DPP shall only give his consent if he is satisfied that, due to the investigation, there is likely to be new and compelling evidence to warrant the conduct of the investigation, and it is in the interest of justice to proceed. If the DPP's consent cannot be given in urgent circumstances, the investigation may proceed with the authorization of an office not below the rank of a senior superintendent of police. Once investigations are completed, the DPP shall apply to the Court of Appeal to quash an acquittal of a trial court proceedings. The acquitted person must be charged for the offence for which he has been committed, or a warrant must be issued for the arrest of the acquitted person. The Court of Appeal may, on application of the DPP, dismiss the application or allow it if the Court of Appeal is satisfied that A, there is new and compelling evidence, B, there is a tainted acquittal as a result of the commission of an administration of justice offence, and it would be in the interest of justice to proceed with the retrial of the accused. The accused, of course, Madam Speaker, has the right to be present for the proceedings. The Director may make only one application to the Court of Appeal to retry an acquitted person. Once the order has been made for retrial, the Director of Public Prosecutions has 2 months to file the indictment. Where the Director of Public Prosecutions fails to file the indictment or apply for an extension of time, the accused may apply to set aside the order and restore the acquittal. Publications of the retrial are restricted, but exceptions are made in certain circumstances. We turn next to the Criminal Procedure Act, Madam Speaker. Clause 6 of the bill provides for the Criminal Procedure Act to be amended in Section 33 to provide an exception to this section by renumbering Section 33 as Section 33(1) and inserting a new section, Section 33(2). The exception would prevent autrefois acquis from applying to offences listed in Schedule 1 of the Supreme Court of Judicature Act, and where the DPP has advised that the acquittal is not a bar to prosecution. Madam Speaker, I will now move on to the abolition of the year and a day rule. From its earliest origins, dating back to the 13th century, the rule has evolved from one of procedure to a substantive rule of law. The rule forms part of the common law definition of murder. It has been incorporated as one of the elements of the offense that the prosecution must prove in order to secure conviction. It goes to the heart of the charge and determines whether or not a person can be charged with a homicide offense. At present, it operates as a bar to the right of the prosecution to prove that a defendant caused death if more than 1 year and a day have elapsed between the act or omission that caused injury and the subsequent death of the victim. The rule is not constitutionally protected as saved law, Madam Speaker, by Section 6 of the Constitution. Neither does it form part of the entrenched rights in Sections 4 and 5, namely the right to a fair trial, protection of the law and not to be deprived of liberty unless by due process of law. Accordingly, the abolition of this rule will not infringe upon any of those entrenched rights, and therefore the legislation that we are contemplating today will not be required to be passed by a special majority. Additionally, Madam Speaker, it may be argued that total abolition of the rule can leave room for abuse of process, either A, because the prosecution has manipulated or misused the process of the court so as to deprive the defendant of a protection provided by the law, or to take advantage, unfair advantage, of a technicality, or B, on the balance of probability, the defendant has been or will be prejudiced in the preparation or conduct of his or her defense by delay on the part of the prosecution, which is unjustifiable. It has been well established, Madam Speaker, in the jurisprudence of Trinidad and Tobago that the court has a discretion to exercise its inherent jurisdiction to stay proceedings for an abuse of process. And our jurisprudence is replete, both here in Trinidad and Tobago and through the common law, with case law to that effect. The most common basis upon which this discretion is exercised is delay. That is to say, whether the delay is such as to deny to the accused a fair trial. The ultimate objective of this discretionary power is to ensure that there should be a fair trial according to law, which involves fairness both to the defendant and the prosecution. As stated by Lord Diplock in the case of the Queen and Sang, the fairness of a trial is not all one-sided. It requires that those who are undoubtedly guilty should be convicted, as well as that those about whose guilt there is any reasonable doubt should be acquitted. Furthermore, the case of Bell and the DPP of Jamaica, 1985 appeal cases 937, the Privy Council laid down guidelines for determining whether delay would deprive an accused of a fair trial. The relevant factors were said to be A, the length of the delay, B, the reasons given by the prosecution to justify the delay, C, the responsibility of the accused for asserting his rights, and D, the prejudice to the accused. As such, it is established that there are safeguards in place to prevent any abuse of process if the rule is abused. In the circumstances, Madam Speaker, there are many arguments supporting the abolition of this rule. Some of those arguments are the danger that the application of the rule to modern conditions could lead to absurd results. For example, in cases of deliberate HIV infection, problems may arise where an infected person may survive up to 12 years after infection before succumbing to death, or in the instance where a victim of violent crime has lapsed into a coma but is maintained on artificial life support beyond the year and a day. The injustice created in cases where perpetrators of serious offenses avoid prosecution completely or may be charged for lesser offenses such as attempted murder or causing grievous bodily harm where a victim dies beyond the year and a day. Life can now be prolonged, Madam Speaker, following serious injuries for periods which could never before been contemplated as a possibility even 30 years ago. Advances and improvements in medical science, especially in the field of forensics, highlight how it is now possible to ascertain cause of death, and in particular to identify a specific causal link between action of the perpetrator and the death of the victim. Pathology has developed to a degree where cause of death can now often be established with certainty over a lengthy delay between the injury and death in cases where, even a relatively short time ago, it would have been speculative to try to do so. Clause 5 of the bill therefore provides for the total abolition of the year and a day rule. The Offences Against the Person Act would be amended by inserting a new section A stating that the rule is abolished for offences involving death. The abolition would not, however, apply retroactively. The abolition of the rule, Madam Speaker, will remove the time limit within which death must occur before a prosecution for murder or related offences can be commenced. Madam Speaker, of course, it must be noted that Clause 2 of the bill contains a proclamation clause necessary to ensure that all stakeholders are prepared to execute these amendments. Prosecution is therefore allowed. Proclamation is necessary, therefore, to prevent collision of laws and to allow for an adequate period of inquiry and safeguarding. Madam Speaker, today we are here to give further protection to our citizens and to ensure fair process and to ensure that offenders are not protected by rules of law which have existed for centuries. With the new technological advances, new evidence can be obtained by the police to prove the commission of serious offenses such as rape and murder. The rule against double jeopardy should not protect offenders. Additionally, these same technological advances can keep victims of grievous bodily harm alive for more than a year and a day. The retention of this rule seems pointless in today's society where technology can prove guilt. Today, I ask this Parliament to consider the proposed amendments which will ensure that the doors of justice remain open to protect the citizens of this Republic. Madam Speaker, I beg to move.